Welcome back, everybody, to the Aaron's High Cap Adventure Radio program. Again, today is March 25th, 2017, and we got lots going on. If you want to be part of the show, 254-697-6633. You want to send me an email, aaronsgunshop@gmail.com, or just go directly to the website, aaronsgunshop.com. And please, if you like this show, show your support. Go to the sponsors, go to my Facebook page, like me on Facebook, give us a call, give us positive feedback, tell us what you'd like to hear, so on and so forth. I'd love to hear your support. Now, we are back on this segment, our attorney lawyer segment, and we're very blessed here to have our special guest, attorney Benton Ross Watson. Ross, welcome to the program again.
It's good to be here again.
I can't tell you how many comments I got from last week's show. I mean, everybody enjoyed listening to the show. They're like, wow, that's great back and forth there, a lot of clarity and all that. So we got something going here, man.
I don't know if it was very clear, but that's my business. So.
The law, it's never clear.
Yeah,
that's
exactly.
why we hire you guys to do the job. I'll tell you what, Ross, why don't you tell everybody, first of all, how they can get a hold of you so they can get your expertise and help them in any situation that they may have going on.
105 East Main here in Cameron. My office number is 254-605-4140. Call it number. I practice general practice here, do everything except for maybe patents and highfalutin tax law. So I need help with that stuff myself. So.
Okay. Hey, I noticed you're drinking a fresh cup of Joe there from Sefco Hilltop.
Yeah.
You see that? Not only does this show drink its coffee, but we got our special guest drinking coffee too. So go get your coffee from Hilltop Sefco. Woo. All right, now, Ross, I read to you the use of force and deadly force that we teach in the license to carry class. I'm a certified instructor in the state of Texas. I've been that way for years, taught thousands of students, okay? But I know, if you pull the trigger and you're in the court of law, they got the prosecutor who loves to win, doesn't like to lose. So he's going to take all this and try and spin it. So I sent you some questions. I'm going to read them here. You're going to give me your take on it. Tell me if I'm missing something. Give me your input. The whole works. And everybody, you need to either get your recording devices out or your pens and paper because there's going to be a lot of good info coming. So here we go. Ross, I'm just going to start off with a question because when we get talking, it goes longer than we're supposed to, and it's all good. But I'm going to start now so we don't waste any time. First question I want to ask to you. Please define more thoroughly the definitions of force, reasonable and necessary force, and deadly force. And if you could, help me out using this gas gauge example of examples that could apply to each one of those types of forces. But I think you may have questions about this definition.
Okay, so this is why you had sent me some of these questions earlier in the week, and I was explaining that a lot of the things that probably we're going to talk about, there's not a really good way. They don't really have a place in the legal world from a legal context, but they do have good application value as far as teaching somebody, how to use a weapon. So I don't want to make it seem like the things you have said are wrong in any kind of way, but legally speaking, right? There's just going to be two, maybe three kinds of force. That's going to be force and deadly force, right? Even the threat to use deadly force is going to be force, okay? And so maybe you can put threats sort of in their own category, but that's going to be force, okay? And it's not considered in the gas station example where he handed him a note and he pulled out a gun, right? That wouldn't be deadly force because he didn't actually use the weapon.
That would be threat. Penal Code 904 threat is justifiable force.
Yes, and because it was only force, right? That he would use deadly force if it were necessary.
Right.
Okay, and so the definitions of any kind of force, it doesn't matter whether it's deadly or non-deadly, is going to be, right, someone's reasonable belief whether that force or deadly force, right, was immediately necessary to protect the person against another, right, who is doing something unlawful. Okay? The only added requirement to that when you have deadly force involved is the same, except you have, was it unlawful, and was the person going to use deadly force against you? So, in other words, if you're coming to hit me or fight me, I believe that I need to use force, right, to prevent you from doing that, and it's immediate, and it is if you're coming to fight me, right, then I'm allowed to, if I reasonably believe I need to use that force, that physical force, to prevent you from using force against me. So the same would apply if you're using a handgun on me, right? I would be able to use a handgun on you because that would be unlawful force from your standpoint, as long as I wasn't doing something to provoke you to use a handgun.
Well, sure, it'd have to be in illegal.
So, and I would more use this chart here that you have force or and with a for people who don't see the screen with sort of a half circle going over to deadly force in this area in the middle where there's reasonable and necessary force. There's really no definition of reasonable and necessary.
Well, let me give you a clarification as to why I do that. We're taking it out of the student handbook. And here's an example, and tell me if I'm wrong with this. If I'm going to use my little gas gauge here and give you an example of force, I would say, what's the most minimal thing I can do besides running away? Running away is a negative force. But if I do, like say, hey, don't do that, stop, that was a verbal command, that's a force. Wouldn't you kind of put that down? Would you agree with me? Disagree with me if I'm wrong. Would you agree that a verbal command would be almost like the very beginning of the force level? And then it can go up from there until it gets to more like in the reasonable necessary force that I describe, where I restrain you or punch you, and then it continues on to where I'm pulling a knife, an axe, a gun, whatever it is to stop you.
I think definitely, that probably so. When we're getting stopped by a police officer, we know when they say stop. I mean, there's some level of force because they have authority to tell you to do so. I mean, I would say that would be the beginning point, to tell somebody to do something, a command.
Okay, so the gauge here, there's a major dividing line. That is from when somebody is being used deadly force upon and then not. If I'm applying deadly force to somebody or I'm not. If I'm not, it's some range of some type of force to almost the extreme point of using deadly force. And I would assume that reasonable people in a courtroom would say, well, he was justified for punching him in the nose, as compared to just saying stop. And that's why I'm using the progressive.
If somebody's coming to do something unlawful to you or your property, right, you have a right to use force. I mean, I would say if you reason to believe that it's immediately necessary to prevent that person from doing the unlawful, right, part of it, to protect that person or that person's property. Unlawful doesn't necessarily have to be criminally unlawful. It can be even tortious, meaning civilly. It can be a civil wrong that somebody is doing to you, but there is that necessity. What was that belief? We're looking. What was the person's belief at the time? I really want to go to the next. I think I see your question. I mean, I want to go into the next thing, which is the objective. What is the objective?
Well, let me read the questions. Everybody's on the same sheet of music. This is a very intense conversation or topic, everybody, because what you think may be right may be totally twisted around in a courtroom. Okay, you have to be very careful here. That's why we're getting into it. Question number 2. Let's talk about the objective. What's the objective of force? Reasonable and necessary force, as we say, or deadly force? Go ahead.
Okay, and so this is another area that I was really got excited about when you asked me earlier in the week. As soon as I saw it, because it really is not going to matter what your objective is a lot of times when you're talking about deadly force. I'll start with force, but I want to at least say that right off the beginning, because you need to have a reasonable belief. What we're going to be looking at in a court is, I'm going to be trying to convince the jury that my client, right, had a reasonable belief, right, that he needed to use that force, and that force needed to be used immediately to protect himself or herself. Okay, and so that I gave you a good example. One of my first jury trials that I had was a lady. It was a combat situation, and a lady used a common kitchen knife, okay, to basically in combat with her boyfriend, right? And it was just a small cut, right, on his hand, right? And we were saying that wasn't deadly force. Now, there were other things in the case, but the jury found that basically it was deadly force. But what we were arguing, it was a reasonable belief from her standpoint to use that knife, okay, regardless of whether it was force or deadly force. But she needed to use that to protect against him who was fighting against her, right? He didn't have any kind of weapon, right? But he was a bigger guy.
Yeah, but isn't it based on the person's perception? Let me give you an example of what I mean by that question. If I got two people being assaulted by, let's say, a cloned individual, a guy 6'7", huge muscle bound, and he's coming to physically do weird stuff to us, okay? And I'm standing here on one side facing one guy, and I've got a 5'2" petite young lady over here, and we both have Glock 17 pistols. They got 17 rounds, and both these guys are identical. They're coming at us. She shoots all 17 rounds, and I do too. With my knowledge, capability, and skills, wouldn't you say that was excessive for a guy like me, if somebody reasonable was looking at, as compared to the young petite woman who was freaking out, scared to death, and using 17 rounds, thinking she had to stop him? Isn't that kind of a depiction of one person's use of force as compared to another?
There are. This is talking hard for professor to explain. There is subjective and objective, right, elements to that reasonable belief. But to not get into that, right, from your standpoint, do you think that you could have taken the guy that's 6'7", the scary looking, that's stone cold Steve Austin looking guy, right, that's coming after you?
In my condition, it's very limited due to the fact I got injuries and all that. So,
do you think that he would cause you serious bodily injury, right, which means something that could cause death, right, or permanent or protracted loss, right, of the use of some kind of limb or bodily member, right? If so, if you think that you would be facing serious bodily injury, we're looking at your belief. Is that belief reasonable? If you felt like there was, and you felt reasonably, right, that you needed to use deadly force, right, against that big guy to prevent him from causing you serious bodily injury, right, then I think, you could be found not guilty.
I know, but then you gotta, yes, I understand, but wouldn't you agree that even though I may think my head's going under the bow of the boat, the jury of 12 got to understand it and believe that too? I've got to somehow relay that fear to them.
Exactly.
And that's where the problem comes in, right?
That's where the problem is.
So
exactly.
that's why we do this, ladies and gentlemen. We want to make sure that you understand both sides, what the law says and what you think it says or means, and then what does it mean to those who are going to judge your nanosecond decision.
Let me say one more thing about the objective too. As well as saying, I don't think it doesn't matter if you're going to shoot the person in the foot, right, or the hand. If you pull that gun out, right, and in my opinion, this is my opinion. I may argue it sometime in a trial later, right, because I see facts that are crazy all the time. But I honestly think that if you're going to use a gun and pull the trigger, that's going to be deadly force. And so you can't say what my objective is for that person. Is it to just stop him or kill him, right? Because, right, it's going to be deadly force if you're using a gun. And I've said in that same trial, right, we had the medical expert that got up there and testified that small laceration on his hand, right, could have caused death, right, or protracted if he would not have gone eventually gone to the medical doctor and gotten treatment. Well, that's almost any injury. Almost any injury can get infected or bleed if you don't go get treatment. And so, but the jury still believed in that case.
Intent's a very important thing to convey, because my intent is not to kill anybody. My intent is to stop you from hurting me.
But the capability, what we're looking at in a trial, is the capability of that weapon, right, is to cause force. And I think that the definition of deadly weapon, right, specifically says firearm. So I think that it gives emphasis that if you use a firearm, that's going to be considered deadly force, right? And I'm not saying that there's no argument ever to be made. There's no exception. There's exception to every rule, even this one. That's what my buddy used to say, my lawyer buddy. But I'm just saying, if you pull a weapon out, it's going to be deadly force, even if you were trying to aim for his knee or whatever. Because
just to be clear, Penal Code 904, threat is justifiable force. I could show or display a weapon. We're not talking about the same thing.
You could display the weapon.
But that's not deadly force. I want to make that clear.
But if we're shooting,
that's a different story. Okay. Pulling the trigger. All right, my gosh, this can get so intense. I love it. Let's go to another question. Maybe it'll wrap back around to these other two. Can you please clearly give examples of what you think last resort means? Isn't it different with different people? And I think we just talked about this. The two big guys coming after us. But what would be? Well, give me an example of last resort. What, your head's going in the bow of the boat. The line has been crossed. What?
Again, this was another thing we said. There's no legal. I even researched this last resort issue. I was saying I represent police officers, law enforcement officers in administrative proceedings. A few times I've done that, and was there restraint, the hold that they use, like a chokehold or something? Was that reasonable and necessary? Did they use it Yeah, did they use, in other words, right? For instance, a juvenile that gets out of hand, was a juvenile corrections officer allowed to use this kind of restraint? They should have used this restraint as a last resort, right? Because that could have been a deadly use of that restraint. But as far as speaking about firearms use, defending ourselves, I couldn't find one Texas case, not one law in the books that uses last resort. So, as a last resort, right? Yeah, it may be a good practice application for you, right? But if, again, I go back to, did you reasonably believe that the force you used was immediately necessary to quell, to prevent that threat of harm that was coming at you, right? And that goes maybe to the whether it was excessive or not. What was the reasonableness of that force? But right, again, that's based on the reasonable belief. So it's an easy definition really to remember the basic issue.
I want to give you an example which is almost 100% factual. And I say it's not because everything that happened except the last part. But here's the question. My place gets robbed. My shop. And I'm coming down there at 3 o'clock in the morning. I'm in my pajamas and my flip-flops. And I'm carrying my M4 because I'm like protecting myself. There's nobody around. I'm out in the middle of nowhere. And I see people coming out with weapons in their hands. I'm not hesitating. Okay? It didn't happen, but if it was to happen, you robbed my store. You've got guns in your hands that you stole from me. I don't know if they're loaded or not. I'm not hesitating. How does that fit in this? How am I looked upon? We're in 3 o'clock in the morning and people rob me. I'm not going to wait. No way. My opinion is it's now or never. So, I mean, this can go 20 million different directions. But in an example like that, are people going to still question you as to your intent or the method or your head under the bow of the boat?
The code actually gives exceptions, and I will even cite the statute for you folks. Texas Penal Code 9.31 and 9.32 are the self-defense and use of force statutes. Both of those, right, give exceptions, and they say that it is presumed. Your reasonable belief is presumed to be a reasonable belief, right? If somebody is breaking into your habitation, your place of employment, or your vehicle.
You hear that? That's an awesome clarification. We say it in the class all the time, but you're hearing it from the quote-unquote horse's mouth. Keep going.
Now, I want to make clear, it does say they're attempting to enter with force. And so I just read a case recently where an individual walked into a bar, and he walked in the bar after the bar was closed and was looking for a fight, actually, right, when he walked in there. But the door was unlocked. The door was unlocked when he walked in. And the court said it's not really, what he was looking to do. Even though he got into a fight and that's what he walked in there to do, it really wasn't based on what his intent. He did not use force to enter the bar.
Isn't that splitting hairs?
I mean,
that all that has to do with is a good attorney who spun the jury, right?
Maybe, but it was the appellate court deciding that was the law in that case. And so when they're saying use of force to break in, I would say that they broke in the door or got through a locked door in some way. That would be the force. So if they entered by using force, I think your belief is going to be presumed reasonable. And I know we're almost done, but I do want to say, like Florida, right? They have a stand your ground. It is a solid presumption. So if somebody breaks in, from what I understand, the law in Florida, we've all heard that you're allowed to stand and fire on somebody. Right, and that's going to be presumed reasonable.
Well, we got that here, Castle Doctrine.
It's not the same here. It is a presumption. Here, it is only a legal presumption, meaning the state, right, could try to rebut that it's not reasonable. In other words, they could try to put on evidence that it still wasn't a reasonable belief, but you're not required to retreat in that situation. However, the state can say that your belief is not reasonable.
Yeah, here's a perfect example. It's 3 o'clock in the morning, guy breaks into your house, you shoot him, he dies, he's bleeding your carpet, law enforcement comes, and I always say, you're going to get questioned, aren't you? And the answer is yes. Do you think you have the possibility of staying home that night? Probably so, if you wanted to. As compared to, if you're on the street corner of 5th and Main, something happens, and you do the same exact scenario at 3 o'clock in the morning, and you got 12 witnesses, 12 different vantage points, cops are going to come, they're going to question you, the odds say you're going to jail until they figure this thing out. Would that be a good assessment?
I would say that maybe if there's 12 witnesses, I don't maybe not, but I
My
would
bottom
say
line
there's
of
a
that
good
was-
chance. Yeah, you're going to jail.
Based on what you're saying here in Texas, the law could say that we didn't believe that to be reasonable, even though you thought it was. Whereas in Florida, you're saying it's a given.
Yeah, if you meet the requirements under the law for a reasonable belief there, I don't think that they can charge you here. As opposed, it's going to be was it, was it a reasonable belief? And I think the state could try to put on evidence.
Ross,
that
we
it
could have a
wasn't
3-hour show just us. You know that.
Yeah.
Okay. I'm running out of time. Let me move on to the next question. We already touched on a little bit of it, but let me clarify the question. Verbiage. Shooting to kill versus shooting to stop, control, or neutralize. Please explain how the wrong words and wrong intent is very bad in this very politically correct world we now live in. I think we touched on a lot of that, but you got any other comments on that?
Yeah, I think there is some truth to that. There are some cases where the person intended to, like, really it was shown there was evidence that really they wanted to kill the person, and really it had nothing to do with self-defense. But this goes back to what I was saying. Did you have a reasonable belief, right, that force was immediately necessary to prevent the other person's unlawfulness?
Would you agree that a person getting a license to carry, or anybody for that matter, should take a secondary class in acting? To learn how to cry on demand, show emotions, so that when you're in the courtroom...
Wow.
I'm telling you, because you're going to have to convince the jury of your nanosecond decision of fear of your life, and they're going to go, well, I don't know. Was the door unlocked or not? Was the key halfway turned or not? You know what I'm saying? Was the door lock damaged? It doesn't matter. The guy felt like I was going to die. See what I'm saying? How twisted.
I will say, Rick actually called me this morning. He wanted to tell me about two cases involving the police that don't knock when they enter to execute a search warrant. And there was two cases. One was a white gentleman that was growing marijuana in his house in Burleson County. The other one is the Marvin Guy in Killeen, and it was in the Temple Daily Telegram. It was in the New York Times, right? In both situations, right, there was small kind of drug activity. The police didn't knock when they entered to execute the search warrant, and in both cases, both defendants got up, and their girlfriends were asleep with them. In both cases, they got up, right, and shot, and both of them killed a police officer.
Mm-hmm.
In the one case in Burleson County, no bill by the grand jury, and the other one, the guy's on trial for capital murder. So that tells you, that gives you, and that was from. I mean,
Let me make a comment about that, because I think about, I fear that, because it's such a, I don't even know what the word I'm trying to say. If that happened to me, based on my training and experience, I don't pull that trigger till identified. However, I question the guy wearing the badge. If he's busting into my house thinking I'm the bad guy, and here we meet in the hallway, and he sees me with a gun, guess who's going to get waxed? Me. So this is a very precarious situation. Hopefully, put the proper address on your homes, put a light on it, and say, I'm not the bad guy, he lives down the street.
Yeah.
All right, let's finish this up here, Ross. Please explain or reiterate the importance of being prepared with this knowledge, and how not being prepared can be fatal for you both physically and legally.
Well, not being prepared, let's say that you don't know how to use your weapon, and you don't know how to unlock it, or you don't know, really, you haven't practiced with it, so you're not comfortable with it. So you think somebody's breaking into your home, and you go and you're trying to get your weapon straight because you're not comfortable using it, and you go downstairs and you just start firing off because you're in such a rush from just trying to get your weapon up, right, that you're not thinking about what it is. What if it's your...
You're absolutely right.
What if it's your cousin?
But I was speaking of actually not knowing these laws. How important is it these people need to study these laws and understand them and get the concept ideas of both how it's instructed and about how you're coming across on it. How important that it's a lack of knowledge. What can it do to them in a courtroom?
But that's why it's important to know how to use your weapon, because if you know how to use it, you're going to grab your weapon, be comfortable, and then you can think about, okay, what can I do legally? Instead of being under pressure, right, in a pressure situation, and just running down there and not being what a jury would find as ordinary and reasonable person, right, and just start firing off.
Now, everybody, that's awesome. Ross just showed his expertise. He took something I said, clover leafed it back in, and made it all work. That's awesome. You did a great job. You need to be on. You need to have a radio show. Okay, we're gonna finish it up here in the next 45 seconds. Ross, anything else you can add that I may have missed when it comes to the use of force, reasonable and necessary force, deadly force, so on and so forth, in 45 seconds? I know that's hard for an attorney. I know.
Lacks the. I think we covered our bases here. I mean, you're going to be asking me to go into a bunch of cases, but I will say this: you don't have to retreat, and you can use deadly force if you're in a place where you have a right to be. You have not provoked the other person, okay, and you're not otherwise committing a crime, right? The law is going to be on your side. If you don't meet one of those three exceptions, one of those three requirements, if you're doing something wrong, or you're talking smack to the other person, right, or you're in a place where maybe you don't have a right to be, okay, then
you need to call Ross, Benton Ross.
You probably need to get your pocketbook ready, okay. And the last thing is if it's criminal trespass, right, you got to make sure when you use deadly force, right, that it is necessary to use that force. And I agree with that point to say it's reasonable and necessary. If somebody's just trespassing on your property, like even an insurance man that comes say, you can't just start firing off. It's going to have to be.
You would think that's common sense, but common sense isn't too common anymore, you know?
Right. It's
yeah. All right, Ross, tell everybody how they can get a hold of you real quick.
105 East Main here in Cameron. My office number is 254-605-4140. I appreciate the show. I have to answer these questions almost all the time, so if you got a question, you can just call me and we can talk about it.
Keeping you on the razor's edge, man. I'm keeping you sharp, right?
Yeah.
All right, Ross, thanks.
Thank you,
Take
man.
care.
I appreciate it.